Good morning, everyone. I'm Lauren LaFlamme with Bankers Insurance, and welcome to our webinar about 2024 changes to the independent contractor rule. We will be reviewing how the changes in the independent contractor rule impact your organization and discuss the specific changes to the regulation. Presenting today is Jamie Hasty from SESCO Management Consultants, and we partnered with SESCO for many years, and since 1945, SESCO has provided human resource and employee relations consulting throughout the country. If you're a client of Bankers Insurance, we encourage you to take advantage of the SESCO services and just ask your insurance sales executive how you can get access to SESCO. This webinar will be recorded, and I will share the recording with everyone at the conclusion of this webinar. Please place your questions in the chat as you think of them. And with that, I'll turn it over to Jamie Hasty, Vice President of SESCO Management Consultants.
Thank you, Lauren, and good morning, everybody. It's good to be back with you all. We do these quarterly webinars with bankers and their valued clients. So sounds like we have, based on what Lauren and Austin were sharing with us, a very large group today, which is exciting, to talk a little bit about some of the changes that are hitting on March 1st for the independent contractor rule. Now, please remember not to shoot the messenger here as we go through some of the topics on independent contractors who can and who cannot be. There are a variety of capacities in which we look at these relationships. But moral of the story, between the IRS, the Department of Labor, and the state test, it is incredibly difficult to 1099 somebody at this point in time. Will that change and revert back once we, get through election season? Who knows? That's kind of what keeps us on our toes in HR, is that, regulations change, interpretations change, they revert back to old rules. So we always continue to monitor that as well. Lauren kind of did a nice little intro, but just to kind of give you a background on SESCO, we are the oldest HR consulting firm in the country. Since 1945, we have clients nationwide in all industries, small organizations all the way up to Fortune 100s. Keeps us very busy, but we're very blessed for that. We have had a longstanding relationship with Bankers Insurance dating back to 2013. And there is access to SESCO through our SESCO and Bankers client program. Some of you all are already enrolled in that program. If you have no idea what I'm talking about, as Lauren mentioned, reach out to your account rep or your account manager, and we can talk a little bit more about that, about how you may gain some telephone and email basic access to SESCO for HR related questions. So let's jump right on in. So when we talk about an independent contractor, and gig workers, right? We're in the gig economy here, especially post-COVID. People are doing side jobs, people are doing more consulting, all of these things, right? So when I look at a gig worker or a true independent contractor, these individuals are hired on a short-term basis. They're working for multiple companies. They are doing specific projects, specific tasks for these companies that they're working for. And they really are freelancers, right? So an independent contractor, a gig worker, is not on your payroll. There is no W-2. They're typically a 1099, right? We as the organization are not responsible for any of their employment taxes. We're not withholding anything. We're not remitting anything to the state or to the federal government. They are responsible for, their own fees and dealing with their taxes and saving for that. And the reason why a lot of organizations want to utilize 1099s is because it's less administrative burden, right? I don't have to offer benefits. I don't have to worry about taxes. I don't have to worry about oversight and management of these people. It makes life easy. However, I will be 100% transparent with you. When I go into organizations and we are auditing payroll, we are looking at all of the HR systems. One of the questions that I'm going to ask is, who do you have on 1099? And the next question is going to be, well, so who else in the organization is performing those tasks that is a paid employee? And in most of the situations, there's overlap there, right? Which is a huge red flag to me as a consultant, as an auditor, because that means we've got misclassification. And then what we do is we start talking through this process of looking at the 3 legal tests to determine if somebody truly is an employee or an independent contractor. When you have situations where we want to hire a consultant, or we want to bring on what we think in our minds, or what we want to do is bring on a contractor, there should always be a conversation with either your employment attorney and or a firm like SESCO before we do anything, before they begin the relationship, because what we don't want to do is have misclassification. If it's one person, yeah, that's an annoyance. We can fix it. There may be a little bit of liability. But when we start looking at organizations that have a significantly larger liability, 50, 100, 500 misclassified individuals, that is devastating to an organization. That can bankrupt an organization. And we're going to talk a little bit later on about some of the financial penalties associated with misclassification from a Fair Labor Standards Act, from a workers' comp situation, as well as other benefits. Okay. We do not want to, if we possibly can, avoid it, have misclassifications of employees. And like I said, 9 times out of 10, when we dig into what this person is doing for the organization or the industry that you all are in, they are with 99% certainty an actual employee and should be on W-2. Okay. And so then we have to go back and we have to look at our liability. We have to reclassify. We have to, get things in order to make it right. So we're going to start off with the 3 legal tests, and I'm going to start with the easy one first. Okay. The IRS has their own, what we call 20-factor test that looks at, is somebody an independent contractor? And this is solely dealing on the purpose of federal and state taxes and workers' comp. Okay. IRS has nothing to do with the Federal Department of Labor. Okay. So IRS 20-factor test, are we giving this individual instructions? Are we telling them when, where, how we want the work done and how they're going to do it? Are we training them on our policy, our procedure, our way to do these tasks? Are these services being rendered personally? Is the contractor physically doing the work, or are they subbing it out? Okay. Are they bringing on their own team? Do they have their own workers? Is this for a short period of time? Is it a continuing relationship, or are we spreading this out over years? Okay. The longer the relationship is there, the more likely it is that they are an employee. Do they have the ability to set their own hours of work? This ties back into the instruction piece, right? A contractor has to have the ability to determine what they're going to do, how they're going to get it done, and when they're going to get it done. There should be no control over set work hours. A lot of times organizations will say, oh, well, you need to perform these services within, Monday through Friday or Monday through Wednesday between the hours of 9 and 12. Well, now we're controlling. That implies employee-employer relationship. Is this a full-time job? Is this contractor exclusively and solely working for only your organization? If so, they're an employee. Okay. A true contractor has to have the ability to work for the general public and to offer their services to the general public. Okay. Is there an order or sequence required by us in how and when the work is performed? Must it be done in a specific order? If we are delegating that or requiring that, then again, we've taken the control away from the contractor to determine how and when this work is performed. Are they doing work on our job site? Or are they working from home? Are they working from their own office? If we are limiting when their work is going to be solely done on our job site, again, that's delineating control. Are they required to provide us ongoing or regular reporting? Okay, that will imply control as well. How are they going to be paid? Is it weekly, monthly, hourly, salary, a flat fee when the job is completed? And more importantly, are they invoicing us on a basis per the terms and conditions of their agreement? And we'll talk about what an agreement really should look like. They have to be invoicing us. They have to be showing their time. They have to be showing the tasks that were completed. If we are also paying them at or around the same time that we're running payroll, that's a huge red flag to the IRS as well as the DOL. Okay. Are we covering their business expenses, their cell phone, their travel fees, all of these things? Did we give them a company laptop? Did we give them access to company email with their, Jamie Hasty at abccompany.com? Okay. Again, implies employee-employer relationship. They need to be using their own things, their own tools, their own equipment. Does the independent contractor have investment in the facilities where we work? Can they suffer a profit or loss on the job? Are they going to make money doing whatever this task is for us, or can they suffer a loss? More importantly, and this one's very critical in the eyes of the IRS, is the independent contractor doing work that is integral to our business? Okay. Any sort of integral business work is going to be an employee. Okay. Are they working for one or more company at the other time? Have they made their services available to general public? Can they quit or be fired with or without employment liability? Okay. So these are the things that the IRS looks at in terms of tax and workers' comp liability. Not every single factor has to be met. We look at it in a totality piece, which is part of that conversation and walking through the relationship before we decide, are you a 1099 or are you truly a W-2? Okay, so that's the IRS 20-factor test. So 3 things that it really boils down to, and the big pieces with the IRS is the behavioral control. Do we have the right to direct and control how that individual performs his or her services? They also are going to look at the financial control. Is the pay, the reimbursements, the tools, the materials? That's a big piece. And then the relationship of the parties. Is there an actual independent contractor agreement in place? Also strongly suggest you don't create your own. You need to be working with an expert in employment law to craft that for you. Okay. So, if there is no defined relationship, if there is an offer of benefits, if, these services are a critical part of our business, they're an employee. All right. Also remember that the second type of test that we look at is the state. Each state has their own Department of Labor, and within that, they have their own regulations and requirements. We call it an ABC test to determine if an individual is an employee and or a contractor. Similar to IRS and similar to what you will see on a federal DOL basis, is this individual free from control and direction of the employer with regard to the performance of the work? Are they performing work outside of the usual course of our business? And are they engaged independently in a different trade, occupation, or business of the same nature of the work that they're performing? Long story short, do they run their own business? Do they have an LLC or an S Corp? Do they carry their own workers' comp insurance? If the answers to those are no, they're an employee. Okay. So just for transparency purposes, this is the old DOL, federal basis economics reality test. Okay. This is what the Department of Labor wage and hour division, if you get audited for a wage and hour audit, one of the things that the auditor will look at through your payroll, they'll request copies of all 1099s. They will request copies of the independent contractor agreements, and they will run those agreements and speak with that individual to determine where they fall within this economics reality test. This is how the DOL catches employers for misclassification of 1099s. This is something that they have been honed in on for the last 5 to 7 years, but now even more so with the change that is coming effective in March, they will be really, really focused on it. Okay. Why? Because it's easy money for the Department of Labor. It's a win for the Department of Labor. They will always find something when they audit you, whether it's misclassification of salaried or independent contractor, or short meal periods, or not paying overtime correctly based on regular rate, or the additional half time on commissions, travel time, and depending on what industry you are in will determine what their focus area is. Right now, they're really focused on healthcare, particularly home healthcare. Okay. Just dealt with an audit for one of my clients who, DOL was targeting 7 different agencies here in the state of Virginia, and they were really looking more so at 1099s because in that industry, healthcare loves to 1099 people when really they should not be. And 2, they were really focused on travel time. Okay. So this is the old test. I'm just showing it to you for transparency purposes. So we're going to move on. Okay. So we have known that modifications to the current independent contractor rule under the DOL have been in the mix since the end of 2022. Okay. But what they did was in January of this year, they published the final rule. It's gone through multiple revisions. It has gone through open comment periods like they do with any regulation that they are changing or implementing. They will announce a proposed rule, then they open it up for a 90-day comment period where business owners, where attorneys, consultants, everybody can comment and provide their feedback. Okay. So the final rule rescinds the 2021 independent contractor rule. Okay. So we are replacing the current rule and we are going back to a very, very restrictive interpretation of independent contractor. Again, this is not uncommon when we have changes in the administration. Former President Trump implemented his version of the independent contractor rule, which tended to be a little bit more favorable towards contractors and gig workers. The current administration is, going back to a more restrictive, which is more employee friendly, meaning that these individuals truly should be employees and not contractors. Okay. So the Department of Labor believes that this final rule will help employers reduce their risk, and it would provide certain added certainties for those who want to be in business for themselves. Whether we agree with that belief or not, that's their stance. So this final rule takes effect March 11th, 2024. So if you have individuals on 1099, this is my friendly reminder that you have 2.5, 3 weeks to really start reviewing those relationships and collaborating with, again, your employment attorney or somebody like SESCO to make sure we've got any liability negated significantly, okay? So the revised economics reality test goes back to 6 final initiatives. Okay, and we're going to break some of these down for you. We're going to dig into them. Just like with the IRS, we look at the totality, how they all play into one another here, and that we should consider and analyze the economic reality of these tests. So test number 1, or factor number 1 rather, is opportunity for profit or loss, depending on the managerial skill, the investment by the worker and the potential employer, the degree of permanence of the relationship, the nature and degree of control, the extent to which it is performed based on an integral part of our business, and then the skill and initiative associated with that individual. Okay, so these are the 6 revised factors that we look at on the DOL test. Okay, just like I mentioned, no one factor, it's not oh, they meet this one, we're good. We got to look at the totality here, okay? Each factor and the weight given to that is based on the facts and circumstances of your customized relationship and need with this person, okay? So factor number 1, opportunity for profit or loss. Based on their managerial skill, based on whether they have the ability to initiate business expertise or judgment. Okay. So things that we're looking at, can they determine or negotiate their rates of pay for the work that they are providing for you? Oftentimes I see employers say, well, you know, I want to hire you to come in and do this. Here's what the job pays, period. There's no negotiation. The contractor can't come back and say, okay, well, my billable fees, my hourly rates are $200, $400, whatever it may be. Okay. So they have to have meaningful negotiations and be able to charge the employer based on their skill set, based on their area of expertise in performing these services. Okay. Does the worker accept or decline jobs, or has the ability to choose the order in which I want to do these services? Okay. Is this worker engaging in any sort of marketing or advertising and other efforts to expand their business operations? Again, they have to have the ability to work for other clients, other organizations. If it is yes, I'm a gig worker, but the only thing that I'm doing is working for you on, 40, 45 hours, it's not going to fly. Okay. Does the worker have the ability to hire in other consultants, other contractors to, again, grow and support this contract? Are they renting their own space? Are they purchasing their own materials and equipment? Okay. If they have no opportunity to make a profit or a loss with this relationship, it's a no-go. Okay. They have to have the ability to win or lose in this relationship. Okay. So generally what we also are going to look at is based on the scope of the services, are they adding in time, reducing time? If it is a fixed rate per hour or per job, that does not reflect their ability to exercise discretion and judgment for the services that they're performing. Okay. Factor number 2, investments by the worker and the employer. Okay. Are any investments that the worker is doing, is it a capital or entrepreneurial in nature? Okay, so things that DOL looks at. The worker, the contractor, are they, are there costs for them for their tools for those specific jobs? Are we charging that back to the employer? Are we making investments or entrepreneurial investments into my own business? Okay. If there is, any sort of increase in our ability to do different types of work or more work, reducing costs, extending market reach and research, those things are indicative of an independent contractor. Also looking at a relative basis of the employer's investment in the overall business, okay? If the employer is investing in certain services and the contractor is also investing in some of those services, they don't necessarily have to be equal dollar value, but we do look at that as well, okay? Investments that would allow the worker to operate independently in that particular field or industry, okay? If there is a lack of investment, that would indicate employee status. And factor number 2 is kind of a weird one, I'll be honest with you, when we're talking about investments. But the DOL is going to look at that. Factor number 3, degree of permanence of the relationship. How long is this in effect? Is it 1 month, 2 months, 6 months contract? Is it like a 4-year contract? The longer they're with you, the frequency of that is going to imply employee status, okay? Is the relationship indefinite? There is no timeline. It must also be non-exclusive. You cannot put a non-compete provision, which, by the way, most states now have regulations on. You can't even use a non-compete if you are under a certain compensation threshold. And there is regulation in the works through the FTC to put a nationwide ban on non-competes anyways, right? So again, if this agreement that you have with this party says, well, you can't work for, XYZ company because they're a direct competitor for us, well, you've created an employment relationship, okay? So how long in duration is the relationship? Is it non-exclusive? Is it project-based? Is it just kind of as needed? As things pop up, we may reach out and contract you to do those things, okay? When we look at regularly fixed periods, whether it's seasonal or temporary, that may not necessarily just indicate independent contractor either, okay? If an individual cannot perform work on a permanent basis due to operational characteristics, due to the industry, then this also does not necessarily indicate contractor status unless they are exercising their own business initiative. Factor number 4, degree and control. Again, this one plays well into the IRS 20-factor test, right? So you will see some similarities here between the DOL and the IRS. So again, I got to be able to make my own schedule, do what I want, when I want, how I want it. There's a difference between keeping the CEO or the president or the general manager informed of, hey, here's where we're at in this, project or implementation or what have you. But if that president, GM, CEO is managing my performance and, realigning expectations and setting, specific measurable outcomes, then that is indicative of an actual supervisor to employee relationship as well, okay? Again, got to work for somebody else. Is there a device that they are using electronically to monitor or manage the performance of the work? Does the employer have the ability to supervise and discipline this contractor? It's not uncommon for us to run into a situation where an employer has said, yeah, I'm going to bring in this consultant, but oh, by the way, here's our employee handbook. Here's what we're going to expect you to adhere to. Well, that's an employee. If you're requiring them to comply with your policies and your procedures, outside of normal regulatory compliance, right? Specific safety initiatives within your organization or specific reporting initiatives, or requiring them to take your annual sexual harassment training. That's all employee stuff, right? A contractor doesn't participate in that, okay? And then last one here on nature and degree of control. Does the contractor have the ability to set their prices or rates for services? Okay, and are they marketing those again to the outside general public? Factor number 5 is an interesting one. Is the work that this contractor or individual is going to be performing for your business, is it an integral part of your business? Is it work that is critical, necessary, or central to your business operations? Is it IT and you need IT because you're a healthcare organization and you have to have, HIPAA and ECW, Clinical Works, and all of these things? That's necessary and critical to your business. So that means that IT person is really an employee, not a contractor. Okay. If the work performed by them is not critical or necessary or central to our principal business operations, then they may be a contractor. Okay. So we're looking at which specific functions are they performing and how that plays into our overall business operations. Factor number 6, this is our last one. Do they perform or use specialized skills to contribute to a business-like initiative? Okay. If they are not specialists in their area of expertise, they're not a contractor. Okay. If they are depending on training from you as the employer on how you want the work done or how it should be done for your industry, they're not a contractor, they're an employee. Okay. If they are bringing certifications and specialized knowledge and content to this to grow your business, to develop your business, to implement a whole new division, sure, they may be an independent contractor. Okay. So we've got to look at where is their specialty there and how that also plays into our business initiatives. It can get very gray, when we're talking about these relationships. Again, not everything is just, well, they hit 2 factors, but not 4. Where do we fall, right? So we look at all of the tests to help you determine really if somebody is an employee or a contractor. And in most situations, I will tell you, they are an employee. And that can be a tough conversation with clients, right? Because oftentimes we hear from clients or, members that they're like, well, this person doesn't want to be a W-2. This person wants to do this on 1099. It's easier. That's what they want. Can I just do it because that's what they've asked for? And the answer is no. Why? Because you have financial liability as a business. Remember that employees cannot waive their rights to certain entitlements under state and federal law. Okay. We also remember that misclassification has both an IRS tax liability as well as Department of Labor, FLSA, the Fair Labor Standards Act liability. So when we have individuals on 1099 that should be a W-2, the money's add up very, very quickly. For example, Uber, back in 2022, $100 million. $100 million to the New Jersey Unemployment Trust Fund because they misclassified drivers as 1099s. Okay. P&O Construction, also in 2022, owed $246,000 to the Federal Department of Labor because they misclassified their painters. They were 1099ing painters for seasonal work when they truly should have been a W-2. So there is a lot of financial liability. Everybody thinks, oh, well, if they're 1099, they're in charge of their own taxes. It's not really that big of a deal for us as the employer, and that is a common misconception. Okay, let's look at just the tax side of things. we've got our FICA taxes. The employer and the employee pay a certain percentage, right? Some goes to Social Security, some goes to Medicare. You've got your FUTA taxes, 6%, right? You've got your state unemployment insurance that you have to pay on every single employee, right? So let's use an independent contractor that we paid $70,000 a year to utilize certain services. Well, we owe $5,300 on FICA. We owe $420 on FUTA. Our state unemployment is another $500. So we have a tax liability of $6,300 right off the bat. Okay. Plus any sort of penalties and interest that they impose for that particular tax year. So if it's one misclassification, okay. Goes back to my earlier comment. It may be more of an annoyance, right? It may not completely break the bank. But what happens if that person has been misclassified for the last 3 years? Okay. What happens if we have 50 independent contractors just like this one for the last 3 years? You're talking about significant financial liability just on the tax side before we even roll into the minimum wage and overtime problems that the Fair Labor Standards Act is also going to impose on us when we have a misclassification. Remember that state and federal law requires everybody to be paid no less than minimum wage for all hours that they work, and overtime for hours worked in excess of 40 hours per week. Now, when we're talking about an independent contractor, depending on what specialty they bring to the table, they may be considered white collar exempt from overtime. So kind of hang with me here as we kind of talk through this. Not everybody, if they're exempt from overtime, would have to be paid, 1.5 times their regular rate of pay, right? So again, this goes back to specialty and what they're doing and the task and how that plays into exempt, non-exempt status as well under the wage and hour division. Also, remember that every employee has to keep a true and accurate time record of all of their time spent working on behalf of the employer. So you're going to get dinged because you didn't have accurate time records for this person, right? I don't know when they started work, when they took a break. Certain states, certain localities require breaks after X number of hours. If we're out in California, they have to have a paid 15-minute break after 4 hours. Then they have to have a, unpaid 30-minute minimum lunch, and then another afternoon paid break. If we're talking about New Jersey or New York, there are other regulations that deal with when people have to have breaks. If we're in Virginia, North Carolina, those sorts of things, that's easy. There is no requirement. That defers to federal FLSA when we're talking about bona fide meal periods, right? So your time records need to show when somebody started, when somebody ended, when they, went on a break, when they came back, because if it's less than 20 minutes in duration under the FLSA, that's paid time. Okay. So the time records have to be able to accurately calculate the overtime as well. So with most independent contractors, they're being paid on a flat fee basis. Well, what if that flat fee based on the hours that they actually were devoting to the project really didn't cover minimum wage? Now, it probably does, but hypothetically, depending on what state you're operating in, some states have really, really high minimum wages. Virginia's at 12 right now. It's likely probably going to be at 15 in the next year or two. Okay. So we have to make sure that, the project and the hours are at least covering minimum wage. We have to pay attention to that if they're misclassified as well. Because what happens when you get a wage and hour audit, whether it is dealing with a misclassification for an independent contractor, whether I have inappropriately put somebody on salary when they were considered non-exempt and do overtime, you have what we call back wages. That is a 2-year back wage calculation. If you have ever been audited by the wage and hour division and they come back and they audit you again, Then they're going to look back 3 years. Okay. They'll also look at unpaid overtime at an overtime premium, 1.5 times their regular rate of pay. Friendly reminder here, regular rate is total monies earned. Hourly, salary, bonus, commission, all of those things, travel time. Then what they do is they impute what we call liquidated damages. So let's hypothetically say I owe Lauren $25,000 over the last 2 years because I classified Lauren as an independent contractor. And based on the time that she worked, based on what I paid, we weren't paying overtime appropriately because she really should have been a W-2 because she was doing marketing for SESCO, and that's integral to our business, right? But she wasn't working for anybody else. So that $25,000 that I owe to Lauren under liquidated damages, which the DOL will impute, it's in the regulation, they have carte blanche to impute it, automatically becomes $50,000 right off the bat. Guess who's getting that extra money? Lauren's getting that extra money, not the Department of Labor. You may also be subjected to civil criminal penalties, attorney's fees, cost, individual liability. Okay, it adds up. So let's look at an example here, a recent example by the DOL. And I think I mentioned earlier, healthcare loves to 1099 everybody, particularly the home health industry. It's a bad idea. Don't do it. But there was a recent investigation by the Department of Labor into a healthcare organization where they had roughly 100 direct care workers who were on 1099. Those workers went in, filed a complaint, DOL investigated. Okay. One, they didn't have time records, which is a problem. And two, because they were misclassified as an independent contractor, they failed to pay overtime for the hours that exceeded 40. So just in back wages alone, the judgment that the DOL came to was $182,624 right off the bat. Then they imputed liquidated damages, right? Another $182,000. Then they imputed civil penalties. Because the misclassification, you should have known better. We can add the civil money penalties there as well. That's another $34,000, almost $35,000. So in total, they owed $400,000. You divide that out by the 100 individuals that were named in the audit, and each worker is getting $4,000. You don't get a payment plan on this, folks. You might get roughly 3 or 4 weeks to cut the check, but that's it. Let's look at the construction industry, okay? Because we may have some construction industry folks on the call. A cement cutting contractor misclassified 21 workers as independent contractors. They didn't have pay records. They didn't pay overtime. The DOL actually sued them. So there are 2 ways DOL can go about this. They can audit, or they can go straight into litigation. In this particular example, they went into litigation. $69,000 in back wages, another $69,000 in liquidated damages. Ended up each one of those construction workers got over $6,000. Okay, it's a lot of money, right? Last one example here on the FLSA liability, and I don't say this to scare you, but it's the reality of the situation. A transport company in Michigan. Whether you are, moving vehicles or not, I call them DX drivers, dealer trade drivers. If you're in the automotive industry, maybe a truck driver, moving and shipping vehicles. This particular organization in Detroit had drivers classified as independent contractors. They went to the DOL and said, hey, we think we're actually employees. They're controlling how and when and what we're paid and all of this. DOL sued. $800,000 in back wages, $800,000 in liquidated damages, over $1.6 million for these drivers. Okay. They also individually named the owners within the business. So those individual defendants are responsible for payment. Okay. Those individuals had to file bankruptcy because it ended up equating to $2,300 per worker because there were so many workers misclassified on 1099. Okay. It can bankrupt the organization. I've seen wage and hour normal audits outside of independent contractor misclassifications for salary and overtime pieces that have crippled organizations and required them to close their doors. And it's sad. It can be completely avoidable if you are collaborating and making sure that we're negating wage and hour liability. There's also workers' compensation liability. Remember, if we have employees, they're covered underneath our policy. An independent contractor should be carrying their own workers' comp, right? So if the contractor, who is really an employee, gets injured on our property, we're liable for workers' comp or tort damages. Directors, officers of the company can also personally be held liable. The carrier may deny coverage for injured workers' comps. Independent contractors, excuse me, that can resort in tort claims and lawsuits. If we have people that should have been on the coverage that weren't, that's going to play into our premium audits, right? They can charge you additional premiums on contractors. Okay. What about employee benefits? If somebody was misclassified as a contractor and you're a large employer and we didn't offer them healthcare under the Affordable Care Act, and they went and got a subsidy, or they went and enrolled in a marketplace plan, guess who's paying the penalty on that? The organization is, right? Yes, it rarely comes up, but we need to care about this, right? Employees obviously are offered benefits, medical, dental, vision, 401k, all of these things, life insurance. Do not, if it's a true contractor, don't offer those things. Why? Because that implies employee status. Here's just an example of an organization that, was penalized by the IRS because they had misclassification. Those individuals were actually employees, not contractors, both from a tax purpose, but they also had to look at, well, you didn't offer them benefits per your plan documents. There are ERISA guidelines that most of us have to comply with, okay? Especially when it comes to pension and welfare plans. So this organization had to settle that case for $96 million because they did not offer these individuals enrollment into the pension and the welfare plans. Okay. Do we care now about benefits? Yes, we should. Okay. So best practices to negate our liability. Always, always, always review a potential relationship before we make any determination whether it is in fact a true contractor or an employee. And if it is a true contractor and you have confirmation from your counsel, there needs to be a very specifically crafted independent contractor agreement. Okay. If this is an individual that is going out on their own, encourage them. Look, you need to have an LLC or corporation formation. Don't require it, but that's going to help support a contractor status. And try to avoid having those contractors perform any sort of primary or integral functions of our business. If it is integral to the business, go ahead and just make them a W-2. Okay, so quickly on the contractor agreement, that should flesh out who the parties are, who is defined as contractor, who is defined as employer, what specifically their business name, their LLC, their S Corp is titled at with that federal ID number, and a description of the services that they can provide for your organization. It also needs to outline the performance of those services that the contractor has sole control over the manner and means of how those services are going to be performed. They are in sole control of their own schedule. And they will notify the employer of their start and end time. Okay. The contractor will also be responsible for determining their own place of work. Occasionally that may be on property. That's fine. But when they're there all day, every day, that's an employee. The contractor is responsible for their own business expenses, their own tools, their own phones, laptops, internet. That should not be reimbursed by the employer. Why? Because that implies an employee status. Okay. Require them to submit to you a W-9 with an FEIN, not a social security number. Require them to, in the contract, to submit invoices on a monthly basis. Okay, that outline, here are the jobs that were performed, here are the billable rates associated with that. Specify the amount and how it's paid. Per our contract, are we paying monthly, quarterly, completion, year end of the project? That the contractor and the business agrees that we are not withholding taxes, FICA, unemployment, that the contractor is solely responsible for that tax liability, which will be reported on the Form 1099 MIS at the end of the year. There also should be an indemnification of the contractor to your business for any tax issues. They are not entitled to benefits. They are not entitled to any sort of oversight by you as the employer. Okay. This agreement neither creates an employer-employee relationship, and that the parties deny the existence of anything but a true contractor relationship. The contractor has the ability to work for any client of its choosing. So there needs to be a non-exclusivity provision included in the agreement. Okay. Things to avoid in the agreement. Any sort of language that would determine control over their work or methods. Like I said earlier, limiting, or saying, hey, you agree to 40 hours a week. Okay, that implies full-time status. Anything that would look at primary functions, non-competes, non-solicitation, non-disclosures are going to be a big no-no. That implies, again, employee relationship, reimbursement of expenses, benefits, those sorts of things. We don't want to include those. Okay. I know I threw a lot at you in a very short amount of time. So I am going to stop sharing my screen so I can see if there is some chat here. Oh, okay. Let me scroll up, so bear with me. My company, I'm going to read these out loud. My company is a small business consulting that issues K-1s. I have no W-2 or 1099s. In the eyes of the IRS, my company is a partnership. I have an operating agreement that covers ownership, but the IRS factors could apply in many respects. Am I potentially subject to this test? Potentially. I would suggest that you reach out to both your CPA, because I'm not a tax expert, but then also to an employment attorney or SESCO to kind of talk more specifically about your consulting business. Yes, you will receive a copy of the presentation. Yes, the webinar is recorded. There is a comment. I get that something like IT is integral to our business, but if I purchase outside IT services on an as-needed basis from someone who does it for others as well and controls their own profit or loss, has their own IT business? Question mark. I'm assuming, are you asking if that is okay? It very well could be. Again, if you're contracting with a completely different business on, to roll out a new server, to roll out different things, or upgrade your firewalls, sure, that probably is a contractor, even though, yes, IT is integral to your business. Those more sporadic projects are probably fine. Comment, I would like to see the chart with the new rules, just like the chart you showed with the old rules. Well, so I didn't make that chart technically. That was on the Department of Labor graphic. So I apologize. I don't have that to provide to you. But if they release that chart, then certainly I'll share. Next question is, with the sole control, as a small school, can we say any time outside of school hours for safety? Say that a contractor we hired to fix the air conditioner. The sole control. Yeah, I mean, you could negotiate that. I mean, again, but if you're contracting with an HVAC company or an independent HVAC person, they should be able to come in at their discretion within normal business operating hours. So I'd be careful about that one a little bit. Can you please show us the state ABC test slide again? Yes, let me go back and re-share my screen. Okay. Bear with me here. All right, let me scroll up. Okay. Here we go. Slideshow, current slide. Again, the state ABC test does pretty much mirror both IRS and DOL. Okay. I will stop that. Go back into the chat. Bear with me. I'm moving in between screens here. It's because I can't see the chat when I've shared my screen. So, a comment came in that they suggest that the IC agreement include requirement for general liability or workers' comp if required by law. Yes, I would agree with that as well. Again, that's where your general counsel and consultant will advise you on what should and should not be included in that contract based on what particular state or locality you're operating in, because we also have to, certain states require their own workers' comp insurance for contractors and others do not. Okay. Another question, what if they are like a handyman service? They don't have employees, workers' comp coverage. I use them as needed. Again, I'm going to go back to, do they have their own LLC? Are we, do we have a contract for services? Even if it's on an as needed basis, they still should be quoting the work, those sorts of things. Next question is, if a company changes an IC to a W-2 on 3/1, is that going to throw a red flag? Maybe. It's all in how we spin that situation. There are ways in which we can craft communications to not red flag people, whether that be the individual that's transitioning and or the IRS or DOL. So questions on forwarding the recording. Yes, everybody will get a copy of the recording as well as a copy of the PowerPoint. It looks like, Lauren, that is all of the questions that came through. Again, if you have questions, feel free to reach out to SESCO if you are enrolled in the HR client program. You have basic telephone and email access to SESCO and our employment attorneys on staff. If you are not enrolled, reach out to your banker's rep and we can explore how that may look for you and whether you're eligible to enroll. Quick question that did come in. Can you please comment on commission-only sales situations versus invoice? Not sure I fully understand the scope of what you're asking here. Obviously, I understand commission-only sales depends on industry and how that is structured and a variety of things. So I would suggest that you reach out individually and let's talk more a little bit about that offline.
Jamie, we also have some questions in the Q&A. I can read the questions if you'd like.
Yeah, let me look at those real quick. I apologize.
No worries.
If we pay, okay, question number one, if we pay our ICs through LLCs, are we subject to these regulations? Everybody is subject to these regulations in terms of payment through LLCs, I would suggest that you consult with your CPA. Please put your contact back up on the screen or chat. Yes. SESCO's corporate number, and I'll tell you this now, but I'll also make sure that Lauren sends it out with the PowerPoint and the recording. Corporate number is 423-764-4127. That same question that I just addressed came through on the Q&A, and then also comments about the copy of the recording. Am I saying that Uber and Lyft no longer use 1099 employment models? According to the New Jersey lawsuit, that is correct. Again, I can't speak to directly what Uber and or Lyft do, again, because that goes back down to state regulation as well. But my understanding is most of them have W-2'd their individuals because they are not true independent contractors. Comment that I've been given guidance that even 1099 contractors should take sexual harassment training because companies liable even for contractors. So you can ask them to, but remember, if they are taking your sexual harassment training, just like you are requiring of your employees, and you are asking them to sign off on your sexual harassment policies, that is implying that the individual is an employee. Now, establishing that the contractor in their agreement must abide by all federal and state regulations, which Title VII, which deals with harassment and discrimination, is a federal law, and that we as an organization comply with that law, and we expect you to not engage in harassment of any of our employees. That's a fair statement. So I wouldn't necessarily say that I would require them to take your training. No. Are you responsible for sexual harassment of anybody that steps foot within your organization? Absolutely. Clients, customers, contractors. If you knew or should have known that the behavior was going on, you are liable under the Department of Labor and civil liability. But that would apply to a contractor or anybody that steps foot in your organization. UPS, delivery person, you're still liable for them. Yes, another question about the copy of the presentation. We will get that for you. Was that everything? I think it was.
There is a question about what happens if the individual is a W-2 employee and they perform a duty that is classified as 3508 1099 when it comes to payment? Should that employee be paid as a 3508 1099, or can the pay be added to his W-2 wages?
Okay, hold on. Sorry, that came in as a comment and not like a separate question. So let me look at this. Okay, so they're a sales manager, W-2, and runs a lead, duty done by on and sale a project and earns commission. Is it okay to add the commission to his regular pay? Also, does this jeopardize? So in this question, I would say I need to understand better about what the lead project is and the sale of a project. And again, whether that's integral to the business, because it really may need to be added into his W-2 compensation. And depending on his structure, whether he's fully white collar exempt or partially exempt under partial retail 7I under the FLSA, we may have some issues there, but that's a great example of call me separately and let's dig into it, because I don't have all of the information. Another question, what about an inquire situation where students involved in a short-term 1-week summer program where they participate with young campers during the summering mentor program. We pay them a stipend, but 1099 according to the regulations. I'd say they're likely an employee, depending on, you know, if they are mentoring your campers. But we'd have to look at the facts and circumstances there. Mostly high schoolers. Yeah, then you're dealing with child labor too. So be careful with that. All right, let me make sure I didn't miss any other.
The last question is from Shannon. It should be at the top.
Okay, yeah. We have contractors that meet at least half or more of the items within the test. Can they adjust their pay? We do not dictate their hours. They have personal expenses. We provide some material samples, which don't cost us anything, and some guidance, not designated training. Don't know if they provide services for anyone else, but they certainly can. We don't require exclusivity. So there seems to be more than a few gray areas for us. Oh, Shannon's asking about an audit. Yes, reach out to us. We can explore those options on, you know, making sure, again, that folks are classified correctly. And she is correct, Shannon's comment. There are a lot of gray areas with this, right? So we just want to make sure that we are going through all of the facts and the circumstances of your particular situation so that we can negate that liability there.
Thank you so much, Jamie. Thank you all for joining us today. This webinar has been recorded and will be shared with you. Have a wonderful day.